Hello, everybody. Welcome to Profiling Evil by Mike King with Chris McDonough. We are so thrilled to be here tonight with you. Chris, how are you doing?
I'm doing great, Mike. How are you? It's great seeing you tonight.
Doing well. You know, we're really privileged today to have two experienced lawyers, which all of you can see on the screen with us, from Anderson Law Group in Salida, Colorado. You know, we've been troubled by some misinformation that's been bouncing around on YouTube in regards to conservatorships and guardianships and the transference of the rights to be able to take individual people's assets. And with that, we thought we'd bring these two experts on and try to learn a little more about it. One of the Salidans that volunteered to help in the Morpheus search a few weeks ago was Patti Arthur. She's been practicing law for more than 30 years, which means she understands better than most the detailed technicalities regarding all of the IRS rules around 501c3s, public charities, and all of that. So we were really excited to ask her a few questions in regard to this, but she was bright enough to say she wanted to bring along one of her colleagues from the office, David Johns, who is in the same firm. And David's a former law professor. He's the managing editor of the Green Book, which I didn't really understand what this was, Chris, but it's the Colorado reference guide on estate administration, on trusts, probate matters, and all things in relationship to that, including part of the topic today, which is conservatorships. He also has been practicing for more than 30 years and is a member of the bar of the U.S. Supreme Court, which, having worked in an attorney general's office, that is no small thing, David. So, gosh, I'm really impressed with that. The other thing is, you're the only attorney in Southern Colorado who's actually a fellow of the American College of Trust and Estate. And we just feel so honored to have both of you with us. Thank you for joining us tonight.
You're very welcome. Thank you for having us.
Yes, thank you.
So the first thing we'd like to learn a little bit about is conservatorships. Right? And then, of course, the second is, what really are the IRS rules and the rules around 501c3s, organizations, public charities, and stuff?
Help us understand this transition from guardianships that might occur in other states. And if I wanted to try to somehow transfer guardianship into Colorado, I don't even know if that's possible, but how does all of this work and what's the purpose of this?
Well, that's excellent questions. Excellent. What you need to keep in mind is that every state's laws are different. Sometimes they're very similar, but sometimes they're very different from all other states. So if you have what generally is termed a guardianship in another state, that term can mean a lot of different things. It could mean that a court has appointed someone to take care of another person physically, making sure that they are in a safe environment. Maybe it's a nursing home, or if they need any medical care. A guardian can make decisions regarding the well-being of someone else, the physical person of someone else. That usually happens when another person is incapacitated, is if they're injured, or if they no longer have the ability to take care of themselves, because we all have our own constitutional right to take care of ourselves. And taking away that right is giving someone else that authority. So courts do that based on certain procedures and a high standard of proof, if you will. So in other states, a guardian could also be appointed to and used to take care of someone else's financial affairs. And if a person can no longer manage their financial affairs because they have some sort of dementia or other illness, then a court can also expand that guardianship role to include the management of the financial affairs of a person. Here in Colorado, our terms are split in a guardianship, and a Colorado guardianship is someone appointed to take care of the physical well-being of another person. And we use the term conservatorship. So a Colorado conservator is someone who is court appointed to manage the financial affairs of another person. If a guardian in another state wanted to transact business here in Colorado, they can't just walk in and show their appointment documents from that other state. They need to go through certain procedures to have Colorado sort of recognize their authority. And Colorado
so can I just clarify that? So just to make sure I'm understanding, David, if a court told me it's okay, I own some property in one state and I also own property in Colorado. If a judge tells me in one state, okay, I'm going to let you be responsible for this other individual's property, that doesn't mean that that's necessarily going to happen in Colorado. Am I understanding that right?
That's true, because here in Colorado, Colorado laws control and dictate how real estate, specifically, more importantly, more real estate in Colorado is handled. And only a Colorado law or Colorado court will help recognize and appoint someone that has the authority to transfer or deal with real estate here in Colorado. So an appointment in another state has to be recognized here in Colorado by a Colorado court in order for that appointment to have sort of authority to either lease or sell or manage the real estate property here.
And a lot of times, David, if I remember right, because I used to work a lot of elder abuse cases a long time ago, and the family members would take to the courts. They would go to the courts, and there would be this argument of dementia and a variety of other mitigating circumstances that quite frankly showed that individual did not have the capacity any longer, based on what you've even said a couple of minutes ago. What if somebody though is just missing and they're in another state, or they're from another state, and like you've mentioned, what do they have to argue to the court in the other state? You would think that would make a difference in Colorado, if anything.
Well, it would be necessary to show some sort of proof that a person is missing, and that there needs to be an appointment for someone else to be able to manage the assets of that person, and that there's a need and that there's a potential or a possibility that the missing person's assets will be diminished or harmed, or the legal term is wasted, but diminished in some way, and therefore someone needs to be appointed to control those assets and properly manage them on the benefit or for the benefit of that missing person, and act in what we call the best interests of that missing person. So there needs to be some sort of a need shown for the appointment, and whoever is going to manage that missing person's property, you have to do so in the best interest of that missing person.
So then it seems like the challenge becomes, how is the conservatorship granted, and really how does it become maintained? Are there some easy answers to something like that?
Well, yes and no. There are a couple of different processes by which to someone appointed in another state can come to Colorado and have their appointment recognized by a Colorado court. Very often, a person will need to transfer that guardian or conservatorship case to Colorado. And certain notices have to go to all family members. And if in the case of a missing person, there needs to be a publication in a newspaper saying, oh, in a month and a half, there's going to be a hearing on the potential appointment of this person from out of state to be conservator over a missing person, whoever he or she is.
Now, I hate to keep interrupting, but this just makes my mind race. So how far does that extend into the family that needs to be notified something like that is going to occur?
Typically, the immediate family members would be adult children, a spouse, parents of the missing person. However, it does not extend to siblings of a missing person.
Yeah.
Interesting.
But clearly parents.
Yeah.
And parents, potentially, if there are parents. And any of those immediate family members could object and walk into court and say, wait a minute, whoever is bringing this petition, bringing this action and wants to be appointed, they're not the most appropriate person, and here's why. So they have the right to come in and challenge and object.
So the intent, so it sounds like the intent of that law or the laws, the conservatorship laws, and correct me if I'm wrong, is that the court wants to err on the side of caution that any types of finances or ways of handling that estate is protected in the best interests of the missing person, not necessarily in the interest of the person filing for that conservatorship. Would that be an accurate assessment, David?
That's very accurate. Yes. The laws here in Colorado are geared towards protecting that missing person or protecting the injured person and making sure that whoever is appointed conservator or guardian acts only in the best interests of the person.
Yeah, if we used a car accident as a use case, for an example, and somebody goes into a coma and then the hospital puts them into an induced coma, and it looks like maybe for a time they're going to be in a trauma center for a while, and a family files for conservatorship to maintain that estate, and then all of a sudden they come out of it. That would be a perfect example of the court protecting the rights of that individual who may not necessarily have the mental capacity to make decisions for themselves.
That's right. The court has to sort of step in and protect that injured or a missing person and make sure that any appointments are made appropriately to help ensure that. And there are, if there was a Colorado conservator appointed, that conservator then needs to come up with a financial plan and present it to the court. And as far as the management of those assets, if there's a proposal for selling any of the assets, why would the assets need to be sold and for what purpose? Where would the proceeds go to, and how would those be managed? And on a yearly basis, report to the court what that conservator is doing. And again, there are a number of ways in which a conservator in another state can come into Colorado. And this is, I think, the primary one is transferring that appointment, and then the Colorado court will has oversight over the future of management of all the assets, and there's certain accountability.
So I just had another thought when you said that. So if an individual is in another state and purchasing items in that state, but yet utilizing the assets of the conservatorship, when they come back into Colorado, would the state look at that as potentially fraudulent in nature? Could that be potentially a criminal act if it was deemed that that money was utilized in purchases out of state to kind of circle to kind of a loophole around the conservatorship laws in Colorado? I'm just thinking out loud, but just wondering.
Right. Well, if there's any wrongdoing that happens after a Colorado court is, I'm going to say, involved and has oversight in jurisdiction over the wrongdoer, then there's always that potential of the court, doing some investigation, and
interesting,
especially if there are family members who will, the parents or adult children come forward to sort of raise the red flag and alert the court that, hey, something is not right. We need to investigate this. And then the court would have the ability to take whatever action is appropriate.
You really, the layperson like me doesn't even think about how complex this becomes. The question it immediately poses for me then, David, is does this conservatorship that might be granted in one state somehow carry over to others automatically, or are there processes that people need to be aware of?
If that out-of-state conservator wants to come to Colorado, and I can only speak to Colorado law, then they have a couple of different options on how to sort of have that appointment recognized. And again, going through the process of transferring the appointment into Colorado and into the court wherever that missing person or injured person resides, I think is the best and most appropriate way. And therefore, Colorado law would dictate, and Colorado court would control what happens.
So that makes me wonder then. It just isn't an automatic thing then. I mean, it's, I guess, becomes almost like evidence in a case to transfer to another state, but certainly not a guarantee that those things are going to happen. Is that kind of what you're saying then?
In different procedures, yes. There are some procedures are more complex than others, and there is a procedure that may be a little bit more streamlined, and but does not transfer completely the appointment, and without all the safeguards that I know Colorado has. So it's never automatic. I'm going to say an out-of-state conservator cannot just walk into a Colorado county or city and decide that he or she is going to sell the injured parties or missing persons property without going through some legal process to have their appointment recognized or transferred to Colorado.
Folks, we have David Johns and Patti Arthur, attorneys with the Anderson Law Group in Salida, Colorado. Both experienced 30 plus years in some of the brightest legal minds in that state. We're just grateful that you are both here tonight to educate us on conservatorships and 501c3 nonprofit and charity organizations. And so, Patti, let's go to you for a couple of minutes and kind of have you weigh in. Is there anything that you wanted to weigh in where we talked to David about, but let's kind of have you focus on a little bit in relationship to 501c3s and how that operates in the state of Colorado?
Okay, no, I think everything David said sounds right to me. And I got a D in estate planning in law school, so you know, it wasn't my finest hour when I got that grade. But anyway, I did really well in the tax courses, so here I am. So I think the main question that I see with a lot of people who are lay people that don't understand the process and procedures of becoming a nonprofit is they don't know that there's a difference between these three terms: nonprofit organization, tax exempt organization, and public charity. Now, let's start with the nonprofit. A nonprofit organization or corporation, depending on which state you're in, that is how you organize at the state level. So if you wanted to become a nonprofit corporation in the state of Colorado, you would file articles of incorporation for a nonprofit. Now, some states, they call it a non-stock corporation. Some states, they call it a public benefit corporation or a mutual benefit corporation. Like David said, all states are different. So the first thing that we have to line out is that a nonprofit is a state designation only. It's a state term only. Now, once you're organized in your particular state as a nonprofit, the next step would be to get your tax exempt status. And tax exempt status is only granted by the IRS. So the point I'm trying to make there is just because I've filed articles of incorporation for a nonprofit corporation in, we'll say, Colorado, because that's where we are, that does not mean you are a tax exempt organization. Now, why is that a big deal? Because if you're not a tax exempt organization, somebody can't donate money to you and take a tax deduction. You're just a nonprofit. Now, the next step would be to get your tax exemption recognized by the IRS. And now there are about 28 or 29 distinct types of tax-exempt organizations that the IRS recognizes. It's everything from 501c1 to, I think it's 501c29, and I think one of them is missing. It might be 27 or 28, but there's something in there that was repealed. And so the one that most people are familiar with is, of course, the 501c3. Now, there are other ones. 501c7s are social and recreational clubs. 501c8s are fraternal organizations. 501c6s are things like chambers of commerce. So there's a whole lot of these, but the one that most people are familiar with is, of course, the 501c3. Now, a 501c3 is broken up into two different types. You can either be a public charity or a private foundation. A public charity is a 501c3 that receives more than 33 1/3% of its gross receipts annually from the general public. Now, that could mean membership dues. It could mean donations from the public, gifts, grants, and contributions. It could be government grant allowances. It could be private foundation donations, things along that lines. A private foundation is a very complicated beast, and it's an organization that does not receive its funding from members of the general public, 33 1/3% of its funding from the public. Now, what I see with a lot of the private foundations that I deal with are people who had a family member who had passed away, and the family member wants to honor that person, but they want to fund the private foundation themselves. They don't want to go out there and get money from the public. They want to, a lot of times what I see is somebody had $1 million life insurance policy on a relative and the person died, and then they take that insurance and they form a private foundation with it. Private foundations are a very unique beast. I don't see a lot of them. I maybe see 3 or 4 a year that I set up, but they are not organizations that receive their funding from the public. That's why it's called a private foundation, and that's why a public charity is known as a public charity, because it receives its donations from the public. So there you have the differences. You start at the state level as a nonprofit organization, filing articles of incorporation. You apply to the IRS for tax-exempt status. And if you want to be a public charity, you apply using, there are two different ways to do it. There's a short form and a long form. There's actually a third way to do it. If you're really small, if you're under $5,000 a year of average annual gross receipts, you can actually call the IRS and give them a little bit of information. They'll ask you a few questions, and one of them is a very important question, and they'll let you in the system, and you don't have to file the application. The application, the short form, is called 1023-EZ, and it's a very easy, and it's filed online. And the long form is for larger organizations, and by large, I mean they expect to have average annual gross receipts of $50,000 or more. And that's gross receipts, of course. And so they would file this long form 1023, and it's also an online application, but it's pretty detailed, and they're pretty complicated and long. So
Patti, can I ask a question?
Yes.
Before this is the investigator in me coming out. If I were running an internal shell game with my investments, can I move monies in one protected area into a 501c3 or another protected area independently and without risk, or is that even possible?
So if let's say, for example, now because this is a corporation, all right, it's a corporation, it's a nonprofit corporation. In Colorado, it has to have a board of directors, and in Colorado, we only need 3 officers: a president, a secretary, and a treasurer. So that would be your minimum. Now, if you are one of those officers or on the board of directors of a Colorado nonprofit corporation happens to be a 501c3, you could certainly make a donation of your assets to that organization. Now, depending on the value of that asset, if it kicks out that 33 1/3% funding, annual funding from the public, you will be deemed to be a private foundation, and you're going to be in a world of hurt because you're going to have to pay an excise tax on a lot of stuff. They're very, very complicated. So it's certainly a possibility for people to donate to the organization on which they sit on the board of directors. But when you described it as a shell game of moving things around, I kind of got the sense that you were asking a question about some sort of nefarious movement of assets or laundering or doing something like that, of putting things in there to hide them or something like that. I'm not sure if I got the gist of your question.
No, I think that would be accurate. I guess I look at the movement of money, this laundering process, and if it could be a way to do that, and somehow, I mean, some folks are really good at taking advantage of loopholes. Others are criminals.
They are, and as we learned in tax school when I was getting my master's degree in tax avoidance is legal. Tax evasion is not. And so
Yeah, that's great.
Yeah, so if that answers that question. Now, here's the thing. A public charity has to file a tax return, and there's 3 different types of tax returns. There's a 990N e-postcard for very small organizations that have less than $50,000 a year of average annual gross receipts or assets valued at $250,000 or less. It's a simple postcard, and it's filed online. It takes 2 minutes. The next step up, and I can't recall the dollar figures for this, is the 990EZ, which is a little bit more complicated, but it's not that bad. And then the full form, the long form 990, has a lot more, asks a lot more questions, and that would be like your organizations like the Red Cross and whatnot would file. And those are there's an asset test and an income test to determine which one of those you would file. Now, if you are a very small organization and would be eligible to file the 990NE postcard, you are able to file either the 990EZ or the 990, full 990. I don't know why anybody would do that. It's time consuming and expensive to have a CPA do it, so it wouldn't make sense to me. If you don't meet the $50,000 a year threshold, I don't know why anyone would file that long form tax return. But does that answer that question?
Yeah, thank you.
I had a question, Patty. So let's say an individual opened up a GoFundMe account
Okay.
and there's a substantial amount of money in that GoFundMe.
Mm-hmm.
Is that money capable of leaving that account if it was donated to a specific cause and then transferred over into any one of these 501 tax exempt type of shelters?
So I do have a number of clients who raise funds for their nonprofits, their public charities through GoFundMe accounts.
Mm-hmm.
I do see a number of those. I'm not really familiar with what the GoFundMe rules are, that if you say, I'm raising money to support this animal shelter and people donate it, and then you take the money and put it in your pocket, that's obviously not right. I'm not sure how that would work. I'm sure the animal shelter would be upset. But yeah, I do have a number of clients that do raise funds for their charities using GoFundMe.
So it sounds like the IRS is pretty specific. If you kind of set the guidelines and the purpose of that, fundraiser, because that's what it is, right?
Mm-hmm.
It's a legal way of raising money
Mm-hmm.
for a specific cause, and once that cause is deemed, completed and or done, what options are available in relationship to those funds? I mean, can it go to a family?
Yes, and I mean that GoFundMe is not a public charity, but yes, if you see, and I liken some of those GoFundMe accounts to the coffee cans that you see at the grocery store with the
Sure.
slot in the top and donate to little Johnny's, trip to Rome, or whatever the case may be. I mean, I see those a lot, and I know in Colorado the Secretary of State takes a pretty dim view of that type of fundraising, but GoFundMe is a stable platform, and so if you raise funds on a GoFundMe account and give money to the family, you're not going to get a tax deduction because you're just giving a gift to the family. But if you're raising money through GoFundMe for the Ark Valley Humane Society or something like that, I keep coming back to them, then Ark Valley Humane Society will give you it's called a substantiation and disclosure letter for the amount that you've donated. So Chris, if I gave you $10,000, that would be a gift. It wouldn't be a donation.
Right.
If I gave the Friends of Profiling Evil public charity $10,000, it wouldn't be a gift. It would technically be a gift, but it would be one that I could take a tax deduction for if you had your 501c3 status.
Okay, so now let me to you, David. Could I roll that money into a conservatorship of sort of somebody that I was that I had custody over from an opposite state? Could I take that money raised in Colorado and go to another state, for an example, and tuck it underneath that conservatorship that I have control over?
Well, that depends. If you sort of disclose that that's where the ultimate direction of those funds are going to, then you may be able to do so. If you raise the funds for a different purpose and then shift it like in your shell game and hide the money somewhere else, then I think there's certainly the possibility that the Attorney General's office in Colorado would want to investigate that. And I have heard of the Attorney General's office here in Colorado doing similar investigations of GoFund accounts and purposes, and finding out that the monies just don't make it to where they're supposed to go, and that's a type of fraud.
That would be go fund my fund for me.
Right. Yeah. Go fund my retirement account.
Exactly.
Yeah, that was a really interesting question, Chris. I'm glad you thought of that, Patti. If that makes me kind of go back to something I was thinking of as you were talking, and that is, if I've now set up a public charity in a different state, can that transfer and all of the activities of that other state transfer over, and what would be the steps to something like that?
Here's where it gets good. Now, if you remember, I said a little while ago, I had a very important distinction to make. When you file articles of organization or articles of incorporation at the state level to become a nonprofit, that's at your state level, your articles of incorporation, and I'll use that because we'll talk about Colorado only. IRS requires certain type of language to be in those articles of incorporation. It's called organizational and operational language. It's also known as, and this is the terminology that I use for my clients, is purpose and dissolution language. In other words, there's very specific language that the IRS must see in your articles of incorporation that describe your purpose as being charitable and describe where your assets are going to go when the corporation dissolves. I can't tell you how many times I see that little thing done incorrectly. And the IRS has said it is the reason the highest number of applications for public charity status are rejected, because they don't have that appropriate purpose and dissolution, organizational and operational language. Now, when I file one of these, I use the IRS's exact recommended language. I don't mess around. There are ways you can massage that language if you wish to make it more specific and say we're operating an animal shelter. You can do that, but I don't mess around. I keep it pretty broad. Now, some states like California, they have that language already baked into the form, the online form that you use. So if you fill out the rest of the information on it, it's already baked in. In Colorado, you've got to add that language as an attachment. Today, for example, I saw probably my 100th for this year organization that had filed articles of nonprofit, articles of incorporation as a nonprofit corporation, and all they have in the little box that says state your purpose and other language that you need is our assets will be distributed to another 501c3 upon dissolution. That's not good enough. That fails the organizational and operational test of 501c3 1B of the Treasury regulations. So now, how do you fix that? You file an amendment and you just add that language. And my language is a page long because it comes right out of the IRS Bible for it. Here's the thing. Now, you talked about another state. So let's go into what that was. It used to be that if you organized a nonprofit organization in another state, say Oregon, and then you decided to move all your operations to Colorado, you've already been awarded your 501c3 status by the IRS, and you have your 947 letter. That's what the award is, 947 letter. And you moved from Oregon, you moved your operations from Oregon and reincorporated, and IRS calls it restructuring or reorganization, in Colorado by filing articles of incorporation in Colorado. It used to be that you had to reapply using the 1023 format, either the easy or the long form. There was an old revenue ruling back from 1967, and it was reinforced by a revenue ruling issued in 1977 that only 2 years ago those both were obsoleted. So now what the IRS says is, yeah, we'll take pity on you. If you want to move your organization from Oregon and you want to dissolve it over there and you want to reincorporate here in Colorado, you don't need a new EIN, which is a tax identification number, in certain circumstances, and you don't need to reapply to us if you've done the following three things. The first thing is that you've reorganized or reincorporated as a domestic business entity. So we formerly were an Oregon nonprofit corporation. Now we're going to come to Colorado and be a Colorado nonprofit organization. That's number one. Number two is that you are classified as a corporation as defined in a certain set of the Treasury regulations, not an LLC or something else. it's your corporation as defined in the Treasury regulations. And number 3, this is the really important part, that you're carrying out the same purposes of the exempt organization that engaged in the restructuring. So in other words, that doesn't mean I was operating an animal shelter in Oregon, and now I'm going to operate a museum in Colorado. That's what that's not talking about. And this is what is so interesting about the way the IRS is and about tax law is what they say isn't really what they mean. So carrying out the same purpose as the exempt organization that moved its states means you have that exact organizational and operational language, purpose and dissolution language, in your articles of incorporation in the new state. If you don't, you're invalid as a public charity.
Holy cow.
Yeah, brilliant.
And how do I know this? I have to fix these all the time.
I am so grateful we have people like you that have invested lifetimes trying to understand the intricacies of the law, because folks that just haphazardly make jumps are really putting themselves at risk, aren't they?
Yeah, and what happens is if you're not valid, you've lost your tax exempt status, and any donations that you've given people a deductible contribution for, it's null and void. I'm going to read the exact language for you from a revenue procedure. We call them RevProcs, Revenue Procedure 2018-15. The articles of organization of the surviving organization, that's the new one in the new state, must continue to meet the organizational test of 501c3 1B of the Treasury regulations. That's your purpose and dissolution language. And, I get a lot of my referrals from CPAs because they know that there are these steps that have to be taken. And again, kudos to the IRS. I deal with them all the time, almost on definitely on a weekly basis, sometimes on a daily basis. But this was a great thing that they did. And it relieved a lot of burden on organizations who want to move from high tax states or high expense states to other areas, or they may find that they have better fundraising opportunities in new states. So I'm glad the IRS has done this, but they didn't make it an automatic transfer. You still have to follow the rules.
Wow, couldn't have said it any better. Go ahead, David. Did you want to say something?
Well, I was just going to say, I'm just so glad I only deal with the IRS once a year when I file my taxes, and I don't want to hear from them again. So those that deal with them on a weekly basis, boy,
I have them on speed dial.
I'm always amazed.
So that's great. Patti, question. Can a person donate their house as a large asset?
Now, where I have seen that is in cases where a family or an owner are living in a historic property, maybe one that's on the National Historic Register or something, and they want to set up a public charity or a private foundation for the preservation of this property. They no longer want to live in it. They want to preserve it for historical purposes. So they take what was formerly their ancestral home, their familial residence, and they donate it to this organization to do that. Now, if you want to donate your house that you're currently living in to a valid 501c3, if the value of that house is $300,000, you have to make sure that you get more than enough income from other public sources to make sure that $300,000 doesn't blow out that 1/3 public support test. So you'd have to raise a whole heck of a lot of money to offset that, so you're not deemed a private foundation and lose your public charity status for the time being. If you're going to continue to live in this home that you donated, I've never seen that outside of certain historic properties where the individual has lived in the home as a caretaker and serves on the board of directors or is the executive director of the organization. that is a transaction that if someone came into my office and wanted to do that, I would not get involved with that transaction. Now, here's the thing. If you move a house, let's say it's your residence, you move it into a nonprofit or a public charity, what is the end of that? What is the end purpose of that? Is it so the charity can sell the house and have the money? Then what are you going to do with the money that's in the charity? Are you going to pay? Are you, as an executive director or a board member, going to pay yourself an exorbitant salary? I mean, do you see what I'm getting at here? What would be the end purpose of donating a personal residence to a nonprofit that you set up? Would it be to sell it, pay yourself a salary? Would it be to donate it and move on to something else and have an ongoing tax deduction with carry forwards till whenever? You know, there's a 50% limitation on how much you can deduct every year on your Schedule A for public charities. And so you have a carry forward. And so my question, if somebody came into my office and posed that to me, I would say, what are you trying to do here? What is exactly that you want to do? What do you want to do? Do you want to turn it into a group home for underprivileged children? Oh, okay. Or do you want to turn it into a hunting lodge where you're going to make money? Or do you want to turn it into a homeless shelter? Now, I have a situation that's somewhat similar to that right now, but it's somebody who wants to donate a home to serve as, they want to donate it to a charity that we're setting up, but they want it to serve as a men's winter homeless shelter. Valid reason. But if you're retaining it as a residence, I mean, my question would be, what are you trying to do here? What's going on? Tell me the truth. The last person who needs to know the truth is your attorney, right?
Yeah,
Well,
famous last words, right?
I'd have a comment on that is if I were a conservator and over a missing person and I donated that missing person's home for ownership into a charity, I would have to prove or establish that that's in the best interest of that missing person. And I don't know what argument I could come up with to prove that or to justify that. I think any conservator who is being monitored or has oversight by a court or has family members who could object would be in a very tough position, I think, to possibly, to prove how is that in the best interest of the missing person.
I have a question for you, David. In these conservatorships, is there a periodic reporting requirement to the courts on the financials or through a guardian ad litem, or how does that work technically?
In Colorado, the answer is yes. A Colorado conservator needs to file a financial plan and has to report to the court on a yearly basis, and also send those reports and those financial plans and accountings of all transactions to all family members as well as the court. So there's a lot of oversight here in Colorado.
Okay.
I'll tell you, David Johns, Patti Arthur, attorneys at law from Anderson Law Group in Salida, Colorado. Our lives are better because of you tonight. We are grateful for your insight and your legal minds. And thank you for sharing that with us, Michael. I mean, I don't have anything to say. They have.
No, I'm gonna just ask both of them for any closing arguments and give you just a shout out from us of how much we really appreciate this. Patti, I don't know if there's anything that we didn't really cover. I guess I'd have one question, and that would be maybe around what if I want to transfer this large asset? How is the IRS going to really look at that? And then maybe you could make a closing argument with that. And then David, let's invite you to do the same.
This would be my closing argument. I have noticed that the pendulum is starting to swing back toward higher levels of audit and audit risk. I've noticed that the IRS in the last couple of months has started to go after some low-hanging fruit. There was a lot of time period where you could get away with a lot of stuff because the IRS was so overburdened and understaffed that they just didn't have time to flag things. They could throw a dart at a dartboard and hit the bullseye and you still wouldn't have an audit risk. But I've noticed that, and I've seen the pendulum swing back and forth all through my 30 years of practice and 30 plus. And I've had the sense that lately, in the last few months, they're starting to get a little bit more aggressive at looking at transactions and examining returns in the independent sector, which is another term for the nonprofit sector. That would be my closing argument. So large asset transfers, unusual grants, especially unusual grants, which is a type of grant that is unexpected. Those, I get the feeling, are going to be looked at with a lot more scrutiny in upcoming days.
Amazing. Thank you, Patti Arthur. David.
Well, I'd just like to mention that I wish there were more states that had as progressive and innovative laws as Colorado has as far as oversight and court involvement with guardianships and or conservatorships. Because I can't speak to all states, but there are many states, other states that just do not have the oversight, and that brings about wrongdoing by those appointed.
That's amazing. Well, on behalf of Profiling Evil, thank you so much. I expect a bill from our attorneys now for your invaluable time. This is incredible. And please, as you travel the streets of Salida and Chaffee County, extend our gratitude for the way in which you embraced Andy and his little army as they tried to search for Suzanne. And what an honor it's been for us to become your friends. I hope that we can bring you back again and maybe discuss some other issues along the way. Would you do that?
Yeah, I would.
Absolutely.
Awesome.
Yes, Michael, it's been a pleasure. Thank you.
Yes, it's been a lot of fun. Thank you very much.
Thank you. And
Yes,
folks,
thank you.
we'll see you soon on the next broadcast of Profiling Evil. Good night.